We'd like to now talk with you about opening statements. Doesn't it seem like opening statements should be discussed at the beginning? Well, you can't really know how to summarize your opening statement until you've figured out what your witnesses are going to say and how you're going to prove things. So today, now that you've laid out your witnesses and you kind of know what story you're telling the jury, you can go back and summarize that at the very beginning of the trial. It's all about preparation, folks. Remember, the jury knows nothing when you first stand up in front of the jury, and an opening statement is really your first chance to address the jury. An opening statement is a roadmap. It's very neutral. It's not argumentative. You know, the jury doesn't know who you are, and so if you come out guns blazing and all dramatic, they're not going to trust you very much. You basically just want to give them a preview of everything that's going to happen in the trial. What the lawyers say is not evidence. Only what the witnesses say from the witness stand is evidence that the jury can consider in deciding whether the accused is guilty or innocent. So, how do you build your roadmap? Your preview. Do not promise something that you can't deliver. Remember, you're building trust with the jury. And if you say something in opening and the witness doesn't do what you thought they were going to do, it's going to make your side look bad and weaken your arguments. So, in your table of contents, the opening statement, what kinds of things do you want to include? Well, of course, you want to introduce yourself and your client. You want to show the jury that you trust your client. Now, whether that client is the accused or whether that client is someone who's accused of breach of contract in a civil action, you want to introduce them so that the jury gets to know them and begins to trust them. Soon after that, you really want to launch right into the events of the case. You want the jury to understand what type of case it is. Is it a breach of contract? Is it a sort of a crime that needs to be explained? Now, this is where we start getting into a preview of the witness testimony. Remember how you made your list of witness testimony and you broke everything down into the 3 most important points for each witness? This is where you're going to summarize them in advance so the jury knows what to expect. You know, studies show that humans remember things much better if they hear them more than once. So your job in the opening is to get a little bit of that information into their brains so that when the witnesses are on the stand, they recognize what's happening. Also in your opening statement, you want to talk about what you will prove and what your burden of proof is. We'll talk about these a little bit more later. At the end of your closing statement, you want to have a nice summary sentence. Let me give you an example. Members of the jury, at the conclusion of today's evidence, we are confident that you will find in favor of my client, and you will find that the accused is guilty beyond a reasonable doubt of burglary. Let me tell you what the difference is between a civil case and a criminal case. In a criminal case, someone is accused of wrongdoing. They're accused of breaking the law. In a civil case, you're talking about things like breach of contract, things that are not punishable by law, but where someone didn't live up to their side of what they were supposed to do. So your burden of proof in a civil case, let's say you're arguing that someone broke their promise in a contract, is a more likely true than not burden. That means that your side has to prove that all the facts that your witnesses are presenting as evidence are more likely true than not. So both sides are basically having a scale of justice and trying to add a little bit more weight to their facts to tip the scale in their favor. That's a civil case. Criminal case, of course, is much more difficult. The burden of proof for the prosecution is beyond a reasonable doubt. Why is that? Well, you probably all know the idea is that you're innocent until proven guilty. It takes a lot more to put somebody in jail for committing a crime than it does to show that they breached a promise for money damages. If you look at this chart, you can see that if the jury thinks it's unlikely that the person committed the crime, perhaps the person committed the crime, that's just not enough to convict somebody. So the prosecution in a criminal case is trying to show beyond a reasonable doubt, beyond almost to a certainty, but not quite, that the person is guilty. The defense in a criminal case, so someone defending our accused robbers, for example, would want to poke holes in that and show doubt, show that maybe not, possibly not, it's unlikely. that the person might not be guilty. So all of these things need to be covered in your opening statement. You want to cover the burden of proof in your opening statement just so that you show the jury that you understand what your job is as a lawyer in terms of what you have to prove to win your case. It shows confidence to talk about the burden of proof in your opening statement. What else should be in your opening statement? Remember how we looked at both sides? We looked at everything a witness might say and what the other side might try to get from your witness? Well, those bad facts that are out there, those facts that could hurt your case, you want the jury to hear about those from you first. If suddenly it's a surprise from the other side, it looks like you're hiding something. So if you're the defense, if someone has a positive identification and says that they saw your client in a lineup, you have to address that in your opening statement. You have to show that you're going to poke holes in that idea from the very beginning. If the other side is the first to talk about bad facts, you're not going to do very well. So let me give you a sample opening statement for the prosecution in our bank robbery example. Good morning, members of the jury. My name is Jenimae Almquist, and I represent the Commonwealth of Pennsylvania in a heinous crime committed by several people in the bank on Front Street on January 21st, 2020. You are going to hear from a number of witnesses about what happened on that day, the guns that the robber brought into the bank, the terror that the teller felt as she was being robbed. You'll also hear from the security guard who was in a position to observe exactly what those robbers looked like. You'll hear Mr. or Mrs. Security Guard tell you about the height and the weight and the build of the robbers. And of course, you will hear from a distinguished member of the police department who will explain to you the evidence found at the site after the robbery that confirms, without any doubt, that the accused did in fact commit bank robbery. Ladies and gentlemen, I know that I have a heavy burden of proof to show that this person is guilty, and I welcome that burden of proof. I intend, through the witnesses that you will hear today, to prove beyond a reasonable doubt that the accused did in fact commit this heinous, terrifying crime of bank robbery. At the conclusion of the evidence, I know you will agree, and I thank you for your service on the jury. Thank you for your time today, and we look forward to seeing you again soon.